我哋私營骨灰安置。
Right, this is the 16th meeting of the Bills Committee on Private Columbaria Bill, so let's give a start. The Council has yet to resume, but meanwhile, we should continue with our work. And at today's meeting, we'll continue to scrutinize the bill, and we'll continue from what we left off at the 15th meeting. And we completed Schedule 4, Part 1 last time, and this meeting will start from C3608 in the Chinese version, or C3609 in the English version of the Blue Bill, Part 2, Schedule 4. As to whether we're going to complete this scrutiny soon, well, I guess we still have to work hard on it. So let's continue with C3604 or 09. So I'll ask the PAS to lead us. Thank you, Chairman. Well, last time we were on Schedule 4, Part 1, so something about the background first. After commencement of the bill, after the bill takes effect, these are the provisions that will take effect. And Schedule 4 is about prescribed information, recommendation, and essential terms in agreement for sale of interment right. And if we turn to C3609, it says under essential terms the information that must be set out in the sale of an interment right. And A means the names of the parties to the agreement. B, a full description of the interment right sold. And the details are set out in the following, from Roman letter 1 to 5. Roman letter 1 states that if the interment right relates to a niche, the particulars of the niche, including the serial number, location, and dimensions of the niche, should be included. And B2, if the interment right relates to a niche, the nature of the right or interest that the interment right comprises, whether it is capital A, an interest in land, capital B, a right under a tenancy or service agreement to use the niche, or C, a right or interest of any other nature. So all these must be set out. C3611 in the English version, Roman letter 3, particulars of any other services to be provided under the agreement. Again, this must be set out in the agreement for sale. And Roman letter 4, particulars of the duration of the interment right, or Roman letter 5, particulars about any right of the purchaser to renew the interment right for another term on the expiry of the term under the agreement. So again, this should be set out in the agreement. C provides for fees, charges, and other payable sums, and the purchaser should prepare or pay in accordance with a comprehensive list of all fees and charges and all other sum payable, whether recurrent or non-recurrent. And the list should also set out the following. 1. The precise purposes for which the fees, charges, and sums are payable under the agreement. 2. The amounts of the fees, charges, and sums, and the mechanism for any future revision of the fees, charges, and sums. That's because apart from recurrent fees or charges, non-recurrent ones are also included, which may be subject to future revision. And the mechanism for future revision should be set out in the agreement. And then Roman 3, payment methods whether periodic payments during the period for which the interment right lasts, or payment by installment payable on the commencement of each validity period of the seller's license, or any other payment method. D. Without limiting paragraph C, and if the interment right includes a right to renew the interment right on the seller being granted a renewed term of the lease, license, or other instrument under which the land on which the columbarium is situated is held. Because there may be a tenor, say by 2047, and the lease may be subject to renewal. Say, for example, if the seller is to pay premium to the government, then the contribution due from the purchaser to the seller towards the premium payable should also be set out. E. Other essential terms. 1. Arrangements for naming a dedicated person. That is the ashes of which of the person deceased to be interred, and the effecting changes for the dedicated person. And Roman 2. After the interment, the authorized representatives may have to make arrangements for the deceased, and the terms therefore include arrangements for appointing and replacing authorized representatives. And then C3613 in the English version, Roman 3, the circumstances and the manner in which the operation of the agreement may be temporarily suspended, or the agreement may be terminated otherwise than on the expiry of the term of the interment right. For example, the agreement may be temporarily suspended in the following circumstances. In applying for a license renewal, some buildings requirements may have to be met. As a result, the niches may have to be moved for alteration works. So the situation may be a bit different from what is stated in the agreement, and the circumstances of suspension should be set out. And of course, the agreement will be terminated on the expiry of the term of the interment right. But other than that, if the agreement is to be terminated, the circumstances under which it is to be terminated should also be set out. F. The arrangements for handling interred ashes in the event of 1. The temporary suspension of operation of the agreement, and 2. The termination of the agreement, whether on expiry of the term of the interment right or not. So perhaps we'll stop here first. I think PAS has explained in great detail Schedule 4 Part 2 along with Part 1, so perhaps we can go back to the beginning and see if we have any questions. Legal Advisor, C3609 in the English version. 2A, 2B. 1. The particulars of the niche, including the serial number, location, dimensions of the niche. So what other particulars would be included apart from the 3 mentioned here? Well, the particulars of the niche could include a lot of things such as orientation and size, but the essential ones that should be set out, we think, should include the serial number, because the serial number would explain a lot of things, including its location, such that the serial number would enable one to identify the niche. Of course, location and dimensions are also important, but perhaps the operator may think it necessary to include other particulars in the agreement, such as its orientation and the engravings on the of the niche. Mr. Wong Kok Heng, 7 minutes.
Chairman, in respect of 3610, subsection E, And this is about arrangement for naming a designated person and effecting changes of the designated person and arrangements for appointing and replacing authorized representatives. There is one scenario I would like to seek clarification about. For example, A authorizes B. A gives the authorization to B, and after a period of time, B, passes away, and C or D from the same family will take up the task. But initially, A has not given the authorization to C or D, because he would not have envisaged that C or D would turn out to be the authorized representative. So what sort of provision do you have in place for the extension of such authorization? And if not, could you provide for such a provision? Because we all know that the arrangement for the urn would already have been made before the person passed away, and the descendants of the deceased will make the decision regarding the burial, but they will not know, about the arrangements which would be made by the third generation. So after a period of time, given that C or D doesn't have the authorization in writing, then the extension of the interment right for that particular niche may be questioned. Let me, explain this in two ways. I will explain to you how this operates and how the provision can take care of your concern. When we inspect the Columbaria, very often we find that the operators have such arrangements for changes to the authorized representatives, because the period of time involved may be very long. Say in a family, for example, the niche might have been bought for A, but then B passes away before A, then they would have arrangements to cater to such a scenario. The operator normally would require, the person concerned to change the name of the deceased. And under E(1), we already have said that when the arrangement was signed, the parties must specify what those arrangements would be. That is, other than nominating the person to be the dedicated person to be worshipped. That could be changed later on. So we under B1, the arrangements will need to be set out. For example, if the purchaser wants to change the dedicated person to B instead of A, then there will be arrangements in place for the consumer to do that. Well, my question was whether or not, after a certain period of time, the person concerned would not be able to transfer the authorization to another person. And if this could not be catered for, then nobody would eventually become the authorized representative for the niche. So the deceased person has already passed away. So how do we come up with this arrangement? Under B Roman 2, there is the concept of authorization. We understand that the consumer or the person being worshipped may pass away. So the question is, who is the authorized person so the agreement would need to name the authorized representative. So even if the authorized representative, even the person concerned passes away, the arrangements could be taken care of. But if the authorized person passes away and there is no other person who becomes the authorized representative, what's going to happen? Actually, there could be more than one authorized representative. What happens if there is no alternative authorized representative? Let's say the original authorized representative has passed away and there's no one to succeed his position. I think in the LegCo brief, we have already explained that we would lay down the requirements, and we also would ask the consumer to actually, list out in order of priority the persons to become the authorized representative. What happens if there is no alternative authorized representative? Would you be able to cater for such a situation? We've already tried our best to we've asked the consumer and the authorized representative to nominate more authorized representatives. When all the options have been exercised and still there is no authorized representative, there's nothing we can do. That's what I'm asking. Eventually, if there's no authorized representative in the end, so what's going to happen? You may have such a scenario in respect of niches in public columbaria. Have you have any such experience that we can learn from? We can certainly go back and check when we formulated the provisions for the bill. We've tried our best to encompass all possible scenarios. But if eventually there is no authorized representative, we will need to consider what to do. So what is the arrangement at the moment as far as public columbaria is concerned? Well, the niche will be taken back. Well, in the case of public columbarium, a person would need to be deceased before the ashes could be interned. And after it has been interned, there would be no possibility of the niche having to be taken out of the niche. Chairman, in the case of public columbaria, at the moment there is no tenure, and normally we would not require the niche to be, or the urn to be replaced. Well, that may be so for public columbaria, but there is this problem for private columbarium. So if after a period of time there is no descendants that you can identify, what's going to happen? Permanent Secretary? Chairman. If there is no descendant to be responsible, then the way we deal with the ashes would need to be invoked, because that would be the last resort. I think the bill also provides that in the event that there is no descendant to take care of the urn, how would we deal with that? Eventually, if nobody comes forward, then the government will have to take care of it. That which provision would allow for that? There is one part which stipulates clearly that the licensed holder has this obligation. Where there are niches that he cannot take care of, then he would need to, deal with it properly, and the arrangements are explained in Schedule 5. I think we'll be looking at Schedule 5 later on today. So I think we can ask administration to explain that when we come to Schedule 5. Chairman, in respect of the essential information or essential terms in Part 2, we were discussing about the appointment and the changes to the authorized representative. The appointment and the replacement of authorized representatives, the government naturally would consider that would consider these would be the relatives or friends of the deceased. But I think the provision has not ruled out the companies which sell such niches or the representatives. So long as the buyer or the consumer agrees, then they could become the authorized representative. So, for example, if the consumer buys the niche cannot think of any person to become the authorized representative, then the vendor may say that if you have trust in us, then we could be, the authorized representative. Of course, the consumer will have to protect his own rights. At the moment, the consumer would specify an authorized representative who could be a family member or a close friend. So for the consumer should need to know how to protect his interests and consider whether or not he would appoint the legal representative of the vendor. The consumer, in making the important decision to buy the niche, he would consider various factors. And of course, the operator may also offer that his legal representative could be considered as a authorized representative. And as for how the consumer can protect his rights, that is important. But my point is that the vendor may recommend certain person as an authorized representative of the vendor. You have not proposed that in the bill. What you are saying is that all you need is the consent of the buyer. Well, I don't think we can rule that out. At the last meeting, if I remember correctly, Mr. Paul Share said that we cannot assume that the consumer cannot protect their own rights, and we should therefore exhaust each and every detail. Well, the bill doesn't rule out that option, but I believe the consumers would also know what his rights are and come up with the measures to protect their rights. I think your answer is that you have not ruled out the option, which I suggested earlier on. Any person, any company, including the legal representative of the vendor, can become the authorized representative of the buyer. When the government drafted the bill, have you ever considered that this might, constitute a conflict of interest? But while it may appear to be convenient to the buyer initially, in the end it might hurt the interests of the buyers. So do you need to consider whether or not you need to spell this out more clearly? Well, I think there is some problem with the drafting here. I think it's too lenient. And would you consider, tightening it a bit?
Well, on the contrary, I'm not too concerned about consumers, as P.S. Put it. The consumers would safeguard their own interests, but I'm concerned that some may purchase niches first in order to reap a profit. So I wonder if this provision would create this loophole, along with Dr. Kenneth Chan's question. Thank you, Chairman. We'll go back and consider the point, because this doesn't happen uniquely in this situation. We'll go back and consider it. Perhaps we will draw reference from past experience and put it in a broader sense. So thank you, Chairman. I'm on Part 2, Bracket E, Roman number 3. The circumstances and the manner in which the operation of the agreement may be temporarily suspended. So that means these should be included in the agreement. Under what circumstances the agreement may be temporarily suspended. But can I say that under no circumstances may the agreement be, or the operation of the agreement may be temporarily suspended? Can I put it this way? Well, perhaps the agreement would last as long as 2047, but 2047, but the buildings may need to undergo renovation anyway, and we cannot rule out the possibility of temporarily reprovisioning some of the niches. For such a long tenor of agreement, we cannot rule out the possibility of, say, renovation works being carried out in a building at some point in time. And this is about agreeing in advance how such situations should be handled, such that the agreement, well, it doesn't mean that the agreement may be temporarily suspended at will. Now, you seem to be quoting some rational examples, say accidents, unforeseen incidents, or building works that require niches to be reprovisioned temporarily or to be moved to somewhere else. But if it's put in such a vague manner, then I am concerned, because it doesn't clearly spell out the circumstances. Does it mean that subject to mutual agreement, the operation of the agreement may be temporarily suspended? But would it be too lax? Or perhaps to the other extreme, under no circumstances would the operation be temporarily suspended? So what about that? If this must be included in the agreement, we don't want to see disputes in the future. Thank you, Member, for your comment. Now, when we discuss consumer rights in the agreement, because this is, after all, the bill, and it is almost impossible to make it an exhaustive list. We may in future come up with some sort of template for the agreement. And I understand from their communication or the newsletters of the industry, they also discussed the relevant terms, or perhaps in the COP. Perhaps in the future, by way of templates, we can spell out the details for better compliance. Well, I think for point 3, I think I agree with Dr. Chen that this is rather too broad. Is it subject to mutual agreement? If not, is it a must that there should be mutual agreement? Well, it says here that in the agreement, the circumstances and the manner in which the operation may be temporarily suspended should be included. Of course, both parties should agree to that before they sign the agreement. So the operator cannot unilaterally suspend the operation. I understand the member mentioned the problem of unfair terms in favor of operators. We consulted the Consumer Council and we consulted the trade. We understand your point, but please understand that the provision here is about setting out the circumstances in which the situation is to be handled. All right, let's see if there are other questions on this provision. Roman letter 4. The particulars of the duration of the interment right, or is it or and? I'm on C3611 in the English version of the bill. So it should be and instead of or in point 4. Alright, on essential terms, any other questions? This is a rather lengthy part. No? No other questions? So let's go back to C3476, clause 42. Well, before we scrutinized Schedule 4, we completed this part, C3473 in the English version. That is, under what circumstances the agreement for sale will be unenforceable. And clause 42 goes on to talk about cancellation of unenforceable agreement. And 42.1, a purchaser under an agreement that is not enforceable by the seller under section 41.2 or 3, that is to say, if the seller is trying to sell a niche which he has no right to sell, maybe because of tenure longer than the lease, then the agreement may be cancelled at any time after it is made by giving seller written notification, and the agreement will not be enforceable. And if the agreement is to be cancelled, there should be a written notice of cancellation given to the seller. And then, bracket 2, a seller who receives a notice of cancellation under subsection 1 must, within 30 days of receiving the notice, refund to the purchaser all money received under the agreement. Failing to do so would mean that the purchaser will have the right to file a claim against the seller, as mentioned in clause 41. Bracket 3. Well, the previous situation talks about the ashes not being interred yet, but if the interment right has been exercised, things would be different. It would be difficult to resell the niche. So if the interment right has been exercised, subsections 1 and 2 apply, subject to the terms of agreement referred to in section 41.3e. That is in relation to the cancellation of the agreement, how much would the purchaser get in refund, and then the situation will be handled in accordance with 41.3e. This applies to all situations? No, before the ashes are interred. If the ashes have been interred, then it will go under subsection 3. Legal advisor. I'd like the government to clarify this. If the interment right has been exercised, the purchaser will not be able to cancel the agreement. So does it mean that subsections 1 and 2 no longer apply? Well, perhaps the law draftsman can respond to that. Let's say if the ashes have been interred, can subsections 1 and 2 still be invoked? Because according to the agreement, if the ashes have been interred, these subsections no longer apply. For 41 subsections 1 and 2, well, it depends on how the agreement is written, whether 42.1 or 2 can apply. So one should turn to the agreement first before turning to 42(1) and 2 to see if it is enforceable or not. But if it is clearly spelled out here, and that, do you mean that the agreement would override these two subsections? Because we don't know what would be included in the agreement signed by the consumer. Let's say within 30 days, a refund should be made to the purchaser, but perhaps in the agreement it would state within 7 days. So we should follow the terms of the agreement and make the refund within 7 days. That is just an example. We have no idea how the agreement will be phrased. Legal advisor, will there be any problem? Because on the one hand here it says within 30 days, but what happens if the agreement states within 7 days? So we will follow the terms of the agreement according to clause 42, 1 and 2. But this is just an agreement. If the interment right has been exercised, then that means the agreement will be unenforceable or will be cancelled. So that means according to the agreement, no cancellation will be allowed. What about another example? Let's say if the agreement states that the refund could be made within 1 year instead of 30 days. Well, I'm not talking about the interment right having been exercised. Well, if you have been using the niche for 15 years, then for the remaining 15-year period, a refund would be made on a pro rata basis. Perhaps the agreement would be phrased in this way. Well, but I have new questions arising from that. Let's say if we follow 42.2, before ashes are interred, let's say here it says that refund should be made within 30 days of receiving the notice. And if the agreement says half a year, so should we follow 30 days or half a year? Ms. Cole? We should follow the bill, the provision. This one, because it says clearly here how the agreement is to be cancelled and the relevant arrangements. So this provision should be observed. Except if the interment right has been exercised as per subsection 3, then it should be subject to the term of the agreement. Well, why is it that under some circumstances we should follow the agreement, but under some other circumstances we should follow the bill instead? Why is it that for 42.3, under these circumstances we should follow the term of the agreement instead? Well, let me supplement. If you're talking about the days, number of days, and it says within 30 days. And if the agreement says within 6 months, then it will be contrary to this provision. But if you say within 7 days, then it is still within 30 days, so 42.2 is still valid. What about 42.3? If the interment right has been exercised, then subsections 1 and 2 apply, subject to the term of agreement referred to in section 41(3)(e). I don't know how the agreement will be written. Let's say if the tenor goes all the way to 2047, and in 2017 it is decided that the agreement should be cancelled, then for the remaining 20 years the refund should be made on a pro rata basis. Legal advisor, I think the key is this. If the interment right has been exercised in subsection 3, so if the interment right has been exercised, then they should turn to the term of the agreement instead, and that is the key.
Right. Do members have any further questions regarding 42? Mr. Leung Chi Cheong. I think the difference here is the moment at which the application was made for interment, I believe this provision can be enforced. But after interment, I think the two parties may have an agreement between themselves. And, for example, whether or not the tenure is for 30 years, would refund be made for that period during which the niche had not been used? Because if I were the operator, I would not agree to the refund, because you've actually forfeited the right yourself as a buyer. So there are certain agreements which are not fair to the consumers. For example, if you think that after interment you're not pleased with the service of the operator and you want to quit, and if there are certain terms which would penalize the consumer, let's say you've incurred the issues for only a few months and you want to take it out, we have already incurred a lot of expenses, therefore we need to fine you. So how can we protect the consumers in this case? And the provision here simply cannot do that. The bill, I think 42(3) says that if the interment right has been exercised, subsection 1 and 2 apply. That is, as far as protecting the rights of consumers is concerned, the government has struck a balance, and it's not all for the protection of consumers only. So in the end, we still have to refer back to the agreement between the consumer and the operator. So the consumer may find it very difficult to know whether or not, when he apply, whether his interests will be protected. The government is saying that it may not. So would you consider ensuring that the operators would come up with an agreement that is more fair to the consumers? Because we would like to have a better balance of between the two. So especially for the licensing authority, how can we ensure that it can, really, provide the proper checks and balance? Chairman, we've heard many different views as to how we should protect the rights of consumers. Of course, there are others who suggest that the proposed, regulations are too, onerous. But eventually, we're talking about a contract signed between the two parties. We understand, of course, that certain important principles that should apply, and that the terms of the provision should not be unfair. It is also suggested that it is very difficult for us to micromanage everything. But as far as the major principles are concerned, we can certainly go back and think about that. Since the last meeting, we've actually consulted the experts and consumers, and later on we can, provide an answer to the Bills Committee. We would need to strike a balance here. We cannot exhaust all the details in the bill. Yeah, that's difficult. Chairman. Now, of course, right now, there are agreements exist in the business world, and eventually, when there are disputes, the court will make the judgment. We don't know now, when the bill comes into force, the operators will come up with many niches, and there will be abundant choices for the consumers. If there are plenty of choices, then the agreement would favor the consumer. But if it is like what it is now, where there is a severe shortage of niches, then that may not be the case. The government cannot regulate the agreements. If there are disputes, the matter will be taken to the court. But nobody wants to go to the court. So I think eventually, if you want the proper checks and balance, you need to have a licensing regime. In future, there may be many disputes because the agreements are, unfair to the consumers. It's all, lopsided. So should there be some checks and balance? Could we have some sort of, say, demerit system so that the operator will not? Since he has the upper hand, he would actually exploit the consumers. For the consumer, after his family member has passed away, he is forced to sign whatever is in the agreement and have the ashes in turn. Very often it is because consumers are put into this sort of situation that they are being exploited. So I think what I'm saying is that we need proper checks and balance here, and I don't think we should leave it to the court to make the adjudication. But I think in the end, the consumer would need to be a discerning consumer. Well, you have a licensing or regulating body, and there should be checks and balance. If the operator has been subject to many complaints, you may not consider renewing its license. Since last meeting, we've consulted the experts. The question is, well, I think what is most important are the guiding principles, and that there shouldn't be any unfair and unreasonable conditions. But eventually, when there are disputes, matters will be taken to the court for a decision. The court will look at the circumstances and deal with it accordingly. Members suggested that in the course of our discussion, this has been brought up. If you look at C3448, the licensing authority may impose certain licensing conditions. For example, if the trade practice is such that it is unfair and unreasonable to the consumers, then when the operator applies to renew his license, then this would not be considered in his favor. So we certainly consider this, but at the moment, perhaps the committee can allow us to go back and have an internal discussion before we will give you an answer. Mr. Chan, I'd like to follow up on one point for the officials to follow up. I understand that during the summer vacation, the administration has consulted the Consumer Council and the legal experts regarding how we can protect the rights of consumers from the perspective of private contracts, while at the same time taking care of the interests of the operators. Roughly speaking, the principle of the need to be fair and just, I think nobody would dispute that. You say that you will make reference of the telecommunication industry. I think we can very, quickly, switch from one telecom service provider to another. But in the case of the operators of Columbaria, it's not like that, and we cannot take the matter to court so easily. So I think we should wait for the administration to think about this and come back to us as to how, in the drafting the bill, we can ensure that the provisions are fair to both sides. I think this sort of, consumer behavior is not as simple as in the case of, the telecommunication industry. So we need to, regulate the behavior of both parties. I think we need to be more clear as to how we can ensure that that the agreements are fair. If the provision, of course, is drafted in a rather loose manner, but the result is that out of 10 Columbaria bearing operators, some may have contracts with very, very stringent terms, But for consumers who sign an agreement which doesn't protect the interest, then there's nothing we can help them. But then it might be too late, and we wouldn't be able to protect the consumers. So in order to protect the consumers' rights, I think we need to do something about that beforehand. Chairman, I'm not saying that we are copying anything from the Telecommunication Authority, but what I'm saying that this exists in the case of other industries. For the telecom industry, the consumer can change the operator very quickly, whereas in the case of Columbarium, national Columbarium, of course, it is used for a very long time. We said that there are templates for the contracts, but it's not the case that it's not been done before. It exists in other industries. They may have self-regulation, which is different from what we are considering here. All right. If there are no further questions, we'll go on to 43. Next, bracket 1. Bracket 1, 2, and 3 are about licenses. Bracket 4 is about specified instrument. That is bracket 1. A person holding a license in respect of a columbarium should keep copies of all the agreements for the sale of the interment rights in respect of the columbarium, including agreements avoided or cancelled. So he would need to keep copies of such agreements until the expiry of 6 years beginning on the date of agreement is fully performed or is avoided or cancelled. So he would need to keep such records for a specified period of time. Bracket 2, a person holding a license in respect of a columbarium should A, keep a register of agreements for the sale of interment rights in respect of the columbarium, and B, he must also enter the prescribed particulars of each of the agreement into the register within a prescribed period. And bracket 3, person holding a license in respect of the columbarium must make copies of the agreements and the register kept in respect of the columbarium under this section available for inspection on request by the director or an authorized officer, namely a public officer. Bracket 4. Person holding a specified instrument in respect of a columbarium must keep a record on A, the interment and disinterment of ashes in and from the columbarium, and B, the contact details of authorized representatives in respect of ashes interred in the columbarium, so that we'll be able to identify the authorized representatives in case the ashes need to be dealt with. And 5, a person who contravenes subsection 1, 2, 3, 4, and 5 commits an offense and is liable to, on conviction, to a fine at level 3 and 6 months of imprisonment. Level 3 is $10,000 at the moment. Any questions?
Legal advisor. Thank you, Chairman. 43.3. In respect of making copies of agreement in the register to be kept, do you mean that the wording should be slightly changed such that it is copies of agreement and the register? Must keep a copy of, but where should it be kept? Well, they should be made available for inspection by the director or an authorized officer. So if it's kept at the columbarium, then it would be all right as long as it's available for inspection. But does it specify whether they should be kept within the premises of the columbarium or they can be placed anywhere in their office, in the operator's office, for example, or the temple. It doesn't specify the location. But if the director or the authorized officer so requests, they should be made available for inspection. So it doesn't specify the location. Will there be a loophole? Well, perhaps they're stored in a computer, so we don't specify the geographical location, as long as they're available for inspection for follow-up. Any questions? Mr. Wong Kwok Hing. Chairman, now to follow up on your question, can the public inspect them? No, because they involve private agreements between the operator and consumers. We require them to keep records in detail so that we can follow up on the interment. Now we talked about the waiver of columbarium, and there is a register for public inspection. Let's say if you want to patronize the operator, you need to find out if the operator holds a license. But this is about private agreement. Of course, the public has the right to know, but so only consumers can inspect his own agreement, but not others. All right, moving on to C3480.3. It should be about the procedures. I think the administration has prepared a PowerPoint presentation on C3498 or C3499 in the English version. This is quite complex, so we will explain this part by way of a PowerPoint presentation. We'll just highlight the salient points before moving on to specific provisions, so that we have the big picture in mind before we scrutinize the individual provisions. We're on C3498 in the Chinese version or 3499 in the English version, about ash disposal and cessation of Columbaria under Part 7. And also Schedule 5 in relation to the occupation order. That is, the director may apply for an occupation order to handle the ashes, and the operator and the other parties in relation to disposal of ashes. So we're on Part 7 and Schedule 5. They apply to the private columbaria applicable under this bill, so it covers a broad scope. After gazettal of the bill, any person with ashes interred in columbarium or ceases to operate in columbarium, the provisions under Part 7 and Schedule 5 of the bill applies, whether or not the receipt of the ashes for interment in the columbarium or the operation occurs before that day. So it doesn't only apply to ashes interred after it takes effect, but before as well. And regardless of whether it's for the operation, keeping, management, or control of the columbarium. So one cannot put up the excuse that the ashes have to do with the previous operator. So as long as ashes have been interred, the operator would be responsible for disposal of ashes interred in the columbarium. It doesn't only cover the interment or the operator of the columbarium. For someone who operates, keeps, or manages or controls the columbarium, there should not be any improper disposal of ashes interred in the columbarium. So what about disinterment or of ashes or abandonment of a columbarium? As mentioned, now it covers a very broad scope. For example, if the operator has not applied for the relevant instrument, then it applies. Now, if the operator fails to obtain the specified instrument, that is, if he fails to get a license, or that if the specified instrument is not renewed, it is revoked or temporarily suspended, then Part 7 and Schedule 5 applies in relation to disposal of ashes. And it also applies to an operator who decides to abandon the operation of the columbarium before or after obtaining a specified instrument. And also a third party, for example, a bank, in the event of the operation being folded up and being taken over by a third party, the provisions also apply in relation to ash disposal. Just now, DS mentioned the point that is, for ashes not disposed of, ultimately these ashes would return to the FEHD for further disposal. So we can move on to Part 7 and go through the part clause by clause. There'll be PowerPoint presentation as well. So Clause 55, interpretation of Part 7. It relates to the terms in this part. And in this part A, a reference to carrying out the prescribed ash disposal procedures is to be construed in accordance with Section 6 of Schedule 5. And B, a reference to carrying out the on-site portion of the procedures is to be construed in accordance with Section 7 of that schedule. Well, we'll come to that in a moment. Some may need to observe the full procedure, whereas for some others, such as the landlord or the creditor, who subsequently takes over the columbarium, the procedures may be somewhat different. And we would refer to the on-site portion of the procedures. And there is a reference here. Pause here. I think we'll need to refer to the relevant sections. That means sections 6 and 7 of Schedule 5.
好啊，不如我講係啊，因為其實呢個好長。好啊，好啊，好啊，好啊。
All right. Well, legal advisor suggests that we go through the whole concept before reading through the individual provisions, because otherwise I have no idea what Schedule 5 Section 6 is about. And I will need to go back and forth. Okay, why don't we follow the PowerPoint slides then, because it's simpler. So let's talk about the concept. Guiding principle. That's also in CAP 132, drawing reference to the guiding principles there. We believe that this is important because in the future, if the case is taken to court, we would know what to observe.
對於有關死者嘅尊重同埋佢嘅
Any person who have interred ashes in the columbarium should have in mind the should dispose of the ashes in a dignified manner, and the operator's liability or responsibility. Well, as mentioned just now, it doesn't only refer to abandonment of the operation of the columbarium. As a matter of day-to-day business, the operator will also have to dispose of ashes. So, in relation to Section 58 of the bill, the operator should observe the following requirement as the operator's obligation. Otherwise, he would be regarded as disposing of ashes improperly. That is, on the left-hand side, if the person holds the specified instrument, and if the ashes are disposed of not because of cessation of operation of the columbarium, but because, for example, as mentioned, renovation works, then the prescribed ash disposal procedures should be observed. That is why just now we mentioned in detail that the procedures should be provided in the agreement, and also the interment record should also be made such that the government can follow up on the interment procedure, and the operator would not be regarded as improper disposal of ashes. So, as long as the prescribed ash disposal procedures are carried out, the person would not be regarded as disposing the ashes improperly. From 59 to 62, we seek to explain the following. Abandonment of columbarium operated without a specified instrument issued, or going back on its undertaking to carry out the prescribed ash disposal procedure. So the 59 is about operating without a specified instrument.
59 and 60 both said that in the event of the abandonment of the columbarium, certain procedures will need to be applied with, and there will need to be a specified response. And 61 defines what the specified response is, and 62 is about the what the operator should do in carrying out the prescribed ash disposal procedures and the consequences should there be a breach and what would constitute a breach. 63 is about the offenses, that is, and penalties, that is, contravention of the provisions and what the penalties will be. So 59 to 62 says that if the FEHD suspects that someone is abandoning the columbarium, irrespective of whether or not the columbarium has a specified instrument, because 59 we're saying that there is no specified instrument in 60. In the case of Section 60, there is. So if you look at the left-hand side, the box on the left-hand side, that is, if the operator fails to follow the proper procedures and during the specified period of time, provide a specified response to the director. The director may, through correspondence or posting of a notice or by way of gazetto, if it discovers that the columbarium's operations have been abandoned, and when people worship the ancestors during Qingming and find that the premises are no longer in operation, and then the director may issue a letter or post a notice requiring the operator or the person concerned to give a specified response. If that person doesn't give a specified response to the FHD, it would constitute the offense of abandonment of columbaria. On the right-hand side, Now, it's all about the operator giving a specified response to the director saying that he's still operating the columbarium, or that he is telling the director that he is no longer going to operate the columbarium, but he will proceed with the specified ash, disposal procedure. But having done that, he has not, carried out his promise to do so. Then in the provisions would spell out how we would deal with both scenarios. Should there be a breach of Section 58, 59, 56, 60, and 62, that is improper disposal of the ashes, cessation of the columbarium, and failing to implement the honor the obligations, then the penalty could be a fine of $2 million or 3 years in imprisonment, or by way of indictment, the fine could be $5 million and 7 years of imprisonment. We refer to the operator. I also mentioned the liability of the person who takes over the columbarium, who could be the owner or the landlord or the bank. Or if that person takes over the columbarium, then he would still have the obligation to deal with the ashes or the columbarium. Then in which case he may still be in breach of the provisions of the will. He may not have a license and so on. So this is to spell out the obligations of the parties taking over the columbarium, and also about the rights. What are his rights? When taking over the columbarium. And in taking over the columbarium, he will need to comply with certain requirements. Otherwise, there's a chance that he might breach the provisions. Looking at the left-hand side, now there is one provision here. That is, if he already has a specified instrument and the land registry, he has registered that with the land registry, everybody knows that this is a licensed columbarium. If the person takes over this columbarium and at the instrument registered at the land registry has not been revoked, then if he takes over the columbarium, the person taking over the columbarium, or other than the landlord or the bank or the transferee has the obligation to, upon taking over the premises, to within a practical period of time, complete the specified, ash disposal procedures. Say earlier, before we issue the license or the instrument, if the landlord or the mortgagee doesn't know, and he takes over only when he takes over the premises does he discover that the premises have been used to operate the columbarium, then he will still have an obligation. But his obligation in this case is that we would want him to comply with all the ash disposal procedure, but we still give him the option. That is, he can only deal with the on-site portion, and the rest can be handed over to the FHC. Of course, if he could, complete the full procedure, we would prefer that he do this. Next, specified ash disposal procedure. What do they include? In Schedule 5, brackets 5 and 6, there are detailed provisions. First of all, he would need to issue, a notice that he is going to dispose of the ashes. And this person will need to, for 2 consecutive weeks, publish in 3 widely circulated newspaper, 2 in Chinese, 1 in English, a notice to announce his intention to dispose of the ashes in the columbarium, so that affected parties can deal with will be informed. And also, in a conspicuous location in the columbarium, put up a similar notice. And C, he would also need to send a copy of that notice to the licensing committee. And D, he would also need to serve a similar notice to the specified, recipient. And in the agreement, it could be the authorized representative. If the agreement doesn't mention an authorized representative, then he would need to identify whoever is the relevant party and inform that person accordingly. Basically, this is to ensure that the relevant person can deal with the ash of the deceased whose ashes have been interred, and the notice must, pursuant to Section 8, Bracket 4 of Schedule 5, to spell out about the claim procedure. And the party concerned would also need to deal with the ashes and the claims accordingly. Say the author representative or the descendants or the successor of the estate. And also he would need to submit a copy of the transfer of the ashes to the director of the FEHD. That is, he need to inform the director to whom he has handed the ashes to. The designated ash disposal procedure. According to the provision, there are detailed arrangements. I've said that the operator may need to, comply with the full procedure, that is within 12 months, within on-site, or if the operator or the landlord or the mortgagee, before the license is issued, the landlord may not know that the premises have been used as a columbarium, and of course, we hope that he would, comply with the full procedure, and even if he does not, that he would at least take care of the on-site portion. So there are several scenarios. We are now dealing with the first scenario. He must make arrangement for at least 12 months to return the ashes to the parties concerned, such as the authorized representative and the successor to the estate, and so on. And during the claim period, upon the expiry of the claim period, for all the ashes which have not yet been returned to the parties concerned, he should, hand over such ashes to the director. So eventually, any ashes which have not been taken care of will be tendered to the director. And secondly, the site could be used for other purposes, and he should at least make arrangement for a claim to be lodged on site, so that the authorized representative or the descendants or the beneficiary of the estate can lodge claims. Upon the expiry of those 2 months, for ashes which have not yet been returned, the operator may, go to another columbarium. The terms and conditions may not be inferior to the current columbarium. For certain religious organizations, they may have other churches or temples as alternatives, and we will allow them to do that. And secondly, to arrange for the ashes to be transferred to a place off-site. And the third option is to allow for at least 2 months. Within on-site, the ashes may return. After those 2 months, the ashes which have not yet been returned could be moved to an off-site a location where claims could be lodged, and allow for no less than 12 months for claims to be for these ashes to be returned. If the off-site claim period expires 2 + 10 months or 12-month minimum, and the ashes have not yet been returned, then it will still need to return the ashes to the director. Eventually, any ashes which have not been tended to would go to the director. Next, procedure for claiming the ashes. Pursuant to Section 9 of Schedule 5, the operator or the department concerned may need to follow the requirements of Section 9 of Schedule 5 and return the ashes of the deceased to the designated claimant. And there are two scenarios. If there is only one designated claimant, then the whole procedure is very simple. There's no dispute. But we do not rule out the possibility that there might be more than one claimant or even more than two claimants claiming the ashes. And therefore, we need to deal with these different scenarios, and the bill will provide details for that. And B, in the event of scenario B, where there are disputes, then the schedule to the document will also list out the priority of the different claimants. And this part is about the claim to take back the ashes. Before the ashes are returned to the designated claimant, if there's no dispute, fine. If there is a dispute, then upon claims by the claimants, then all the claimants would have the same priority, in which case the matter would need to be settled by the court. Both the operator and the department will not be able to make a decision as to whom the ashes will be returned. And those who contest the claim will need to provide the grounds in court and leave it to the court to make the decision. A is about the person disposing such ashes will need to keep those ashes until the claimant has obtained an order from the court and then follow the order of the court to return the ashes accordingly, or 12 months after the expiry of the claims period, if the court has not yet made an order, then the person who disposes of the claim can return the ash to the director of the FEXD, and then depending on the court's decision in future, return such ashes to the person concerned. Claims for designated objects. The provision said that the ashes include those which have also been, included in the burial. So there are people who may come forward to claim not for the ashes, but for those which have been included in the burial, and we'll need to deal with those at the same time. And we cannot simply follow the procedure we just looked at. And we have to, they need to follow the relevant, provisions. That is, if the person disposal of the ashes, and if someone claims that he is the owner of the designated objects, that the procedure we mentioned just now doesn't apply. He would only need to follow Section 9(8) of Schedule 5, and the court may rule on those claims, and the person, disposing who disposes of ash will need to keep such objects until the court comes to a decision, and then hand over the objects to the person concerned. If 12 months, upon the expiry of 12 months, the court has not yet come up with an order, then the objects will need to be handed back to the director. The director will wait for the court's order before dealing with such objects.
So we covered ash disposal procedures in the bill. It also mentions that the director and the specified person's powers in ash disposal procedures and the right to apply for an occupation order from the court. And it says here that if the procedures have not been fully carried out, that is, if the operator is carrying out the procedure halfway through and not completed, then the specified persons, the director of FEH, authorized officer or public officer can take all the necessary procedure to finish the procedures. And if the court is satisfied that a person has improperly disposed of the ashes, abandoned the operation of a columbarium, or has breached the undertaking to carry out the prescribed ash disposal procedures, then the specified officer can apply for a court order to empower the relevant officers to enter the premises and occupy the premises for a period specified in the order, and the person should be liable for all the costs incurred as a result of carrying out the prescribed ash disposal procedures on that person's behalf. Now coming to Section 14 in Schedule 5, in relation to directors' powers to dispose of abandoned ashes. Any ashes in a director's possession in respect of which the prescribed ash disposal procedures have been carried out, whether or not by the director, may be disposed of by the director in any manner that the director thinks fit. If there are proceedings pending in court in relation to ash disposal procedures, and if the written notice has been served to the director of the proceedings, then subsection 1 doesn't apply. That means if there are court procedures pending, then the power will be withheld until the court order has been given. As for other parts of the ash disposal procedures, a third party or the operator can submit alternative plans for approval by the director, and the director must be satisfied that the alternative is as valid as the prescribed ash disposal procedures that's set out in the bill before approving the plan. So there could be counter proposals on namely the alternative procedures, but they should be as valid as the prescribed procedures in the bill before they can be approved. So we've covered Schedule 5 and the relevant provisions in Part 7. We hope that by prescribing ash disposal procedures, if there are circumstances in which the ashes can no longer be interred in the columbaria, they can still be disposed of properly. All right, so that's the overall situation. Some questions, Mr. Wong Kwok Hing? Well, can you give me a copy of the PowerPoint? Because it's quite lengthy and quite complicated. I don't think I'll be able to remember all of them. Anything to follow up on the procedures? Maybe the Secretariat can distribute the copies. Now, PAS talked about the operator's liability, what would happen in the event of abandonment of operation of the columbarium, and claiming of ashes, claims of specified items. I think they pretty much covered all the circumstances. Mr. Wong Kwok Hing? Well, I thank the department for their detailed explanation of the concept. Now, I'm referring to the end of the PowerPoint presentation. The director of the FEH has the power to dispose of the ashes, so it's clearly spelled out here. Subject to any court order issued by the court, the director may or may not dispose of the ashes. But here, only ashes are covered, not items. Now, usually, would think that the ashes should go with the items as far as claims are concerned. However, there may be, say, the gold watches and other items that are placed in the niche. and there are provisions that allows them to be dealt with separately. In the case of a contesting claim, if the case is taken to the court, then pending any court ruling, we are not going to dispose of the ashes. We'll wait for the court's order before the director of FEH decides how to dispose of the ashes. Same as items, is that right? Please tell us which provision you're referring to. Schedule 5, Clause 9. Chairman, Clause 9. Here, the headline is handling claims for ashes. And the first part explains the terms, the definition of terms, but starting from subsection 3, it covers how the ashes are to be handled. For example, in the first 2 months, the ash handler must not return the ashes of a deceased person. But let's say on the expiry of the first 2 months, in the event of competing claims, the case should be taken to the court. Well, if, however, there is no competing claim, then all he has to do is to wait for 2 months. But I think someone's concerned about other specified items, not just the ashes. Now, for other items, it's under bracket 7, C3639 in the English version. Subsection 8 applies if A, the ash handler is in possession of an item as one related to the ashes of a deceased person, and before the ashes are returned to a prescribed claimant under this section, a person claims to be the owner of the item. And here we use the term specified item, and subsection 8 applies. Subsection 8A, subsections 3, 4, 5, 6 do not apply to the specified item, and the court may determine competing claims in accordance with any law applicable apart from subsections 3, 4, 5, 6. So the court may rely on the common law or other applicable laws in determining the competing claims for the specified item other than subsections 3 to 6. And the ash handler must keep the specified item until a person obtains a court order for return of the item to the person. And then the ash handler must return the item as ordered. If on the expiry of the 12 months after the overall claim period, no court order is made, the ash handler must deliver the specified item to the director. So the director will be in possession of the items. And after the court makes a ruling, the director would act in accordance with the ruling and deliver the specified item to the persons concerned as ordered. Mr. Lam Kwok Hong. Towards the end, it says here alternative ash disposal procedures. So it is in Schedule 5, Section 17. So if another operator or a third party submits an alternative ash disposal procedure to the director, can approve such plan as long as he is satisfied that the procedures specified in the plan are as effective as the prescribed ash disposal procedures. So what if somebody is aggrieved with the director's decision? Is there any appeal mechanism? That is C3651 in the English version, subsection 3. Is there any appeal mechanism? So let's say if I don't agree with the disposal plan that you approve, then can one turn to any appeal mechanism or judicial review? I think first of all, one could inform the director of FEH. Of course, the aggrieved subject can rely on judicial review. So if there is no mechanism, then there is only one way to go, one avenue, judicial review. I think maybe the common law would also allow that. So no appeal mechanism, only JR. Mr. Leung Kwok Hong, are you saying that there should be an appeal mechanism? Just give it a thought. Well, speak into the microphone, please. Because if you, because judicial review is complex, and it's very possible that somebody may be aggrieved. Please speak into the microphone. If the director doesn't heed the demand, then it's troublesome. Let's say if you ask somebody to go for JR instead, first of all, it is costly. Not many people can afford it. It's a burden on the claimant in a JR case. I don't know that should there be an appeal mechanism to handle such situation. Have you thought about it, DS? Now, what we're dealing with is situations in which there may be disputes. Maybe for some reason, the descendants of the deceased may file competing claims for the return of the ashes. And there may be other items apart from ashes, which may be valuable items. And we believe that for these valuable items, I think the law, already deals with the disposal of such property. And we don't think it should be codified in this bill. So we have not included an appeal mechanism here. So I think should there be any dispute, JR may be the avenue. Maybe the court can make a ruling on contesting or competing claims, or the director may exercise his discretion on disposal of ashes. So in the event that there is no court order, and if somebody comes up and demands for the return of ashes from the director, we believe that the law would allow the proper handling of such situations. So in response to Mr. Leung's questions, we have not included an appeal mechanism here. Mr. Leung. Chairman, if the director doesn't exercise his discretion, then there won't be any judicial review. Of course, one can go directly to the court. Say if there's a very nice gold ring or diamond ring as part of the estate, then some may file a claim for the estate. I don't know whether the specified item should be regarded as estate.
Two avenues. One is to go to the court. The other one is to go to the director. So how can we have another appeal mechanism on top of the courts? Now, if the director doesn't have the administrative power, nobody would, apply for a JR in court. But if you give the authority to the director, then he would also have the trouble to make the decision. If there's no appeal mechanism, and I don't know whether there will be such competing claims in future. If JR is the only channel available to the claimants, then all the possible claimants will go after the director, and I think he will be. He would really have to really bear the responsibility, Chairman, in dealing with the estates of the deceased. I think you've just made a very good point. We don't want the director to having to bear that responsibility. Now, if there's no dispute, the matter is very simple. because the ashes can be given back to the claimant. If there are disputes, then we're inclined to leave it to the court to judge. In dealing with estates and so on, we believe that it should be for the court to make the decision, not for the director. If the director has to make the decision and to entertain such appeals, I'm sure the director will not be able to cope. So you're saying that people can, go directly for litigation. Putting the ashes aside, if there are items which have commemorative value or are of a monetary value, then the parties can go directly to the court, right? What is the relationship between the director and the court? What do you mean by either or? I've already said in my answer that if there is no dispute, the director can deal with the situation, and if there is any dispute, then the matter could be put to the court for decision. Mr. Leung Chi-Chiang, regarding penalty, I'd like the director to explain this. That is, for any person. Are you referring in general people who have breached 58, 59, and 60? Normally, our understanding is that this should not include the relative, but rather the operator. And we would tend to, take the operator to be the licensee. And it shouldn't be. And the investigation could become a criminal investigation. Now, if the licensed person violates these few provisions, and once he is indicted, it would be a fine of 2 million and 3 years, or 5 million and 7 years. So I think it's similar to the licensee of restaurants. Very often the licensee is not the bona fide investor. He is simply only the scapegoat. So under the circumstances, if the department were to prosecute, would you only do so after a criminal investigation? Because the licensee may not really be the person to be responsible. And secondly, putting aside the 3-year imprisonment and the fine of $2 to $5 million, is $2 million the maximum. In a summary prosecution or indictment under a summary procedure, the maximum fine would be $2 million. But I think the penalty could also be decided pursuant to indictment. So in which case the maximum fine could be $5 million. So there wouldn't be any minimum fine of, say, 1 or 2 million. No. Could you explain the part about any person? Any person may include not just the licensee. It could be the person who has a license, the exemption, the temporary suspension of liability instrument. It's not that the person applied for such license, and upon the enactment of the bill, if the person doesn't take care of the ashes properly and he doesn't make an application, he would also be in breach. So whether or not it applies for a designated instrument or not. The second question is that even if he is a license holder or the holder of a licensed instrument, the earlier parts of the bill, such as Section 9, already mentioned that depending on the circumstances, the prosecutor would need to look at the facts and circumstances of the case. The department will conduct the investigation and then through the DFJ initiate prosecution. So the process is very, very stringent. One would need sufficient evidence before the person concerned could be indicted. So to answer Mr. Leung's question, PS, could you speak in the microphone, please? So the coverage is very wide. And also, according to the bill, the director will look at the background of the case and the evidence. I'll give you an example. The operator now, I think, would have made an investment in the columbarium. Normally, to operate the columbarium, they would, charge, a fee from the consumer, and they operate the columbarium for several decades. So the operator may not be able to maintain the operation for a long time. He may need revenue from other sources. Just in case, well, such revenue received may be used to make other investments. As a result, the operator may not be able to pay for the expenses. As a result, the columbarium, the operation may collapse, and then the FEXG may need to really take back the columbarium. So would this scenario be caught under 58, 59 all the way through to 62? I think these provisions spell out the liabilities of the parties concerned. The person who operates the premises, or the person who takes over the premises, such a person has the duty to take proper care of the ashes. If he follows the procedure properly, then he is all right. But if he does not, then he may be in breach of the provisions, and the penalties may apply. If he only partially, discharges his liabilities, then we would go after him for the expenses incurred. And we will inform members later on how we propose to do that. Simply put, I think this could become a criminal case because the penalty may include imprisonment. Yes. So any other questions regarding the overall procedure? And if not, because this is a very long section, and we may need to look at it one by one, and we may need to look at the details with a lot more detail. Now it's 4:25. It would appear that this might be a good time for us to stop here because we need to look at the whole section again in detail. So at the next meeting, we will start from page 3614. The date of our next meeting is the 13th of October at 2:30 p.m. Again, in room 2B. So with that, we may now adjourn our meeting. Thank you very much.